we'll start. Hi, morning everyone. Okay, welcome to the first ever Employment Act 1955 training. So for today's session, it's just a very small session with the four of you. These are my staff from Sungai Petani. Yeah, and these are clients from Mr. Wu's side. Yeah, okay. So today's session is going to be a little bit more intense because as you can see in your slides, there are actually a lot of topics that we would like to cover today. And perhaps there could be some topics in which I won't go too deep, but since this is a very small group of people, if you have any questions, please feel free to ask along the way so that we can all discuss together as well. Okay? So this is basically the Employment Act 1955. Okay, so there are a lot of sections inside. It's a very thick acta. Okay, so this book I will pass it to both of you so that along the way during the training, right, I want you guys to also go through the act itself so that you can familiarize yourself with reading the actual Employment Act 1955 instead of just relying on the slides or any other materials out there, so that you know exactly where you can go and refer, in case if anything happens or in case if you have any questions that you want to ask, right? And of course, for trainings like Employment Act 1955, it is very important that I don't expect you guys to remember the exact sections in which anything falls under, right? But it's very important that after this training you will be able to remember, oh, okay, there is actually such thing in the Employment Act, okay? And then you guys don't need to remember the exact details also, never mind, right? But the most important thing is you guys remember the overarching principle, right? The principle, the rationale, and also how things actually work. And then the very nitty-gritty details, like for example, how many days, what's the exact calculation, and things like that. I don't expect you guys to remember. But most importantly, first thing, you guys know that it is actually in the act, and second thing, you guys know where to actually go and look for it, right? This is the most important thing. Okay, so of course, why is Employment Act 1955 important? It's very important because for one main reason only, which is in terms of effective human resource management. Because in order for you to be able to have a business that is sustainable, a business that can grow sustainably in the future, you have to make sure that all your employment practices actually comply with the local acts, right? And of course, is Employment Act 1955 the only act that you guys need to comply with for managing employment relationships? Is it the only act? Dennis?
No, there should be other, law and regulation that we need to comply also.
Yeah. So there are definitely a lot more other acts that you need to comply as well. And during this training, you will be able to see what are some snippets or like snapshots from other acts that are also relevant for managing the employment relationships. But of course, most importantly for this training, it is mainly focused on just the Employment Act 1955. Okay. So I think before we go into the meat of this training, let us all just introduce ourselves first, and I will go first. Okay, so I'm Andy, right? I am a psychology and cognitive neuroscience graduate from University of Nottingham, Malaysia. I am currently a University of London Bachelor of Law student, right? And I'm a certified industrial relations professional, and I've been in the HR industry for slightly more than 3 years now, and I also won the championship in the national IR competition, a couple of months ago. Okay, and of course, the purpose of my training today is so that I can at least give all my participants a little bit of knowledge regarding Employment Act 1955. Okay. So, shall we go? Yeah, you first, Anis?
Introduce me.
Yeah, name, what you do, and also what do you want to gain out of this training? What do you want to learn out of this training? Doing bahasa okay. Tak ada masalah.
Okay, so my name is Hrdc. So I prefer to call Hanis. Okay, so hi. Alright, so I'm currently be a senior sourcing and client service assistant, known as HR. So I've been a HR more than 4 years. Okay, 4 years. So currently I'm a trainer also for the Employment Act. So today I just want to give more knowledge because we call Mr. Andy as Mr. Atta, our Mr. Atta. So I want to know more detail about the Atta lah. Even though I know the EA, but I need to know the deep inside lah. So
Thank you, Hanis.
Okay, hi, I'm Bella. I also from Evercare, Emma. Okay, and then I currently stay at Sungai Petani lah. So now I apa dia tengok lah? HR, also HR. Okay, and then yeah. Tujuan I juga trainer jugalah untuk HR, untuk EA. Okay, so tujuan I join this training untuk kita share kita punya pengalaman juga kan. So I more kepada manufacturing. So banyak kilang-kilang yang kita jaga kan. So mungkin kita boleh share kat sini kita punya pengalaman, kita handle kita punya pekerja. Okay, and then nak korek apa yang ada ilmu yang Mr. Andy boleh bagikan kita lah. Sebab usually kita pun dekat office pun even kita as a trainer juga kadang-kadang kita pun confused betul ke apa yang kita ambil kan, tindakan yang kita ambil tu. So kita pun banyak rujuk dekat Mr. Andy jugalah. So mungkin hari ni kita boleh share sama-sama kan kita punya pengalaman yang kita ada.
Okay,
Thank you, Bella.
yeah, thank you very well. So my name is Hannes. So Hanis a bit. Yeah, it's Hannes
Same.
yes. Yeah. Okay. So I'm currently the QA and compliance manager for Mr. Wu. And then of course, if let's say my past experience actually quite a lot, but mainly it's in F&B industry lah. I've been in F&B industry for I think around 10 years. But of course in between there's a bit others, mainly in operations, retail and marketing also. So of course, and then for Employment Act, throughout my career, of course we be involved in a lot in employee relations, employee matters, all these things. So of course the basic one, of course we will know, and then we got involved in. But of course today is an opportunity lah for us to gain more details about, because some are the things that we think maybe is simple, or maybe it's like the Employment Act is say like this, but if let's say we go too deep, actually it doesn't really mention like this. It's just that maybe throughout the experience we usually or we normally do like this, then we think that the law is like this, but actually not. So today is opportunity lah for us to really know into what is the Employment Act really mentioning or really stated inside.
Okay, thanks, Hannes.
Hi, my name is Bernard. So I've been 11 years in the F&B industry. So for the Employment Act, right, when we start approaching the F&B, we don't know about much about Employment Act. So our company do not have a proper HR. So we learn all the little knowledge from our senior manager. They say, oh, you have the annual leave, you have the works, everything. So even though the show cause letter, warning letter, also we listen the procedure from what they practice, but we do not know are they practicing the correct or the wrong one. So going through like 2-3 companies, so getting more and more understanding about the Employment Act. So I think today is the best opportunity for me as well to learn more deeper insight for the Act, so as if we can apply in our working environment.
What's your position? What's your position?
Position operation manager. Mr. Wu.
Thank you for that.
Normally we don't say position, we just say what we do in the industry. Because in F&B, everyone, even though you're a manager, you're also washing plate. Doesn't matter.
Okay, alright. Thanks everyone. Alright, So since Hannah's also mentioned that he has a little bit of experience, and I believe everyone here has already worked to a certain extent, at least 4 or 5 years or so in the workforce already. So when we are also we also have 3 people managers here as well. So definitely we have been exposed to Employment Act to a certain extent. Right, so it's very important that first thing first, before we start the training, let's do a little bit of quiz just to see whether everyone what is your knowledge regarding the Employment Act, and whether what you think is correct or not, and then we shall explore more during this training. Okay, so just. Okay, scan QR. Oh, you guys want to connect to the Wi-Fi here? Can. Can. Oh yeah.
Yeah.
You can help me check once in a while. Check. Wi-Fi is Sea Talent 5G. And 5G. The 019 423 2622.
Bella.
Who is free?
Auto generate.
Very. Can? Oh, is she on the call? Oh, she's on the call already. You're unready.
Bernardo. L.
Okay. All right. So let's start. So each question is about 20 seconds. So you will have to read and then answer at the same time within 20 seconds. Okay. So you need to pay your full attention.
Quiz.com. Play and create.
It is strictly prohibited under all circumstances for employees' working hours to exceed 8 hours a day.
Wait, Anis.
False.
Okay. I will explain during the training later lah, on why the questions are the way they
A
are.
contract of service can be either written or verbal.
Apa saya?
True.
Why so fast ah? Then lah, it's okay. I think she's using VPN.
Select all the laws that are applicable for managing employment relationships in Malaysia.
Ada lagi 2. Oh, dia kena select lah.
Employment Act 1955. Income Tax Act 1967.
Baru step.
Scan package.
Number 1.
Select all the possible types of employment contracts. Fixed term, full-time employment. Fixed term, part-time employment. Permanent.
Oh, tu boleh kerana. Okay.
There are some that can pick a few. Yeah.
An employer can dismiss his employee immediately, without notice, on the grounds of misconduct or poor performance.
Asyik tak tahu pula.
False.
Kita banyak fikir.
Employer can instruct the employee to stop work immediately after employee submits resignation before the end of notice. True, as long as remaining salary for notice period is still paid in full.
Good job. I think all of you got it correct.
Regardless of their salaries, are entitled to termination benefits if they are retrenched by the company. False, not all employees are entitled.
Tak tahu marah.
The law requires all employers to provide the benefit of salary advance to all employees.
I think there are a lot of trick questions here.
Wow.
False. An employee must give birth to a child who is alive to be entitled to maternity leave.
Alah, salah tekan.
Fourth lah. Alive. Actually, touch wood is not alive. I think also.
Oh, dah betul dah, tak perlu duduk balik. Oh, dia naik. Oh, dah terus.
So maksudnya,
As a female
Bella sebenarnya
employee
salah.
notified is pregnant, she can start her maternity leave. False.
Five more to go.
Okay, kekalkan, kekalkan.
If an employee has just joined a company and gives birth after 1 week of joining, she is entitled to maternity leave. True, but maternity allowance will be subject to eligibility. A male employee's entitlement to paternity leave is restricted to just marriage with the first wife only. False.
Very fast. 1,000 points. 4 points.
Employer doesn't allow employees to leave workstation during lunch break, then the lunch break must be paid. True.
Dah baca balik sebelum
Turun balik, turun balik.
Jangan. Ai, ada lagi tak?
All annual leave entitlements cannot be forfeited and must be encashed at the end of every year. Depending on the scenario,
Dia salah tu.
Gelap sebab dia tahu nak kena.
Final question.
Double
Double point.
Double point, eh?
annual leave balance must be paid to employees even if they are terminated for misconduct. False.
Trik dia yang misconduct tu.
Third place. L. Second place.
Sorry,
Bella. And the winner is Harneys.
Yay!
Okay, more than 10,000. Alright, so I think after the short quiz, everyone sort of know where they stand, right? In terms of the knowledge on Employment Act 1955. So actually it's very funny because a lot of times even our own clients, right, they always tell us, oh yeah, Employment Act 1955, oh yeah, we know what, you know, it's just very common sense only and things like that. Everyone seems to know a thing or two about Employment Act 1955, but a lot of times, especially when it comes to Employment Act, right, there are actually a lot of nitty-gritty, very small things that will cause you know, the whole scenario or the whole law that will be applicable to change altogether, right? Because it really depends on the situation. So just a very quick tip, right, for everyone here. Especially if you're asking about employment-related questions or anything related to the law, right, you should always give your full scenario. Because if you don't give your full scenario to a HR practitioner, we will just tell you based on what the law says. But depending on your own scenario, maybe the scenario might change a little bit, right? And then the whole law that actually applies or is applicable will actually change completely, okay? So, in today's session, what you will actually learn is, first of all, just a very quick introduction to EA 1955, and then the second one is on the types of different employment. So, for example, contract of service, contract for service, right? And then what's the difference between a permanent and also a fixed term contract? And then what is the difference between a full-time and also a part-time employment, right? And then the third thing will be on termination. So what are the different types of termination? What is the law mandated notice period? And then also what is the suspension of work? Okay, and then number 4, this will be on the payment of wages. So for example, wage period, time of payment, calculation for incomplete month, and then limitation of advanced wages, system of payment for wages, and also lawful deductions. All right, and then on the 5th one will be on maternity and paternity leave. And then on the 6th one will be one of our biggest topics as well, which is on the hours of work. Right, hours of work, rest day, holiday, annual leave, sick leave, and also the different rates of payment. Right. So of course, everyone's level on the Employment Act is slightly different in this room, right? But when I'm going through, there might be times in which I might say stuff that I think you would already know. But if you don't know, please stop me at any time so that I can further elaborate. Because if you don't stop me, I will assume that you already understand about what is in the law, okay? So on the first one, so in terms of just a very quick introduction to EA 1955, right? Employment Act 1955. This EA 1955 is actually only applicable to Peninsular Malaysia and also Federal Territory of Labuan only, right? And what about Sabah and Sarawak? So Sabah and Sarawak, they actually each have their own what they call labor ordinance. Okay, so they have the Sabah labor ordinance, and then Sarawak has their own Sarawak labor ordinance. Okay, so if you do meet anyone from who are working in Sabah and Sarawak, you can tell them that Employment Act 1955 is actually not applicable to you guys. Okay, then you might ask me, what is the difference then between Employment Act 1955 and also the Sabah and Sarawak labor ordinances? But actually the difference is quite minor. There are certain differences in terms of the payment of overtime and etc. Right? But majority of the things inside are actually quite similar to Employment Act 1955. And Employment Act 1955, at least in the previous revision, right? So the latest revision for Employment Act 1955 is the one in 2022, right, which was effective 1st of January 2023. So again, if you are looking at the Acts, make sure that you are looking at the most updated one. So usually it will be printed in front on the front page, so you will see when it is last updated. Or if you are looking for an online version, the PDF one, on the first page they will also say when it's updated one. Yeah. Okay. And second thing is that Employment Act 1955, because it's applicable to Peninsular Malaysia, and the Parliament obviously also sits here in Peninsular Malaysia. So a lot of times when there are changes to the Employment Act, right, or to the employment laws in Malaysia, in the entire Malaysia, they will usually make the changes to Employment Act 1955 first. And then after that, the Sabah and Sarawak one, then they will only follow. Okay? So another thing is that EA 1955 is actually only applicable to the private sector employees only. Okay, public sector, government servants, etc., it's not relevant for them. Because for the government departments or the government agencies, they actually have their own rules and also their own regulations that govern their relationships for their employment with the government. Okay, so Employment Act 1955, it mainly focuses on, say, for example, the statutory benefits, what are the statutory conditions, what are the rights and protection of both employees and employers. Okay, so as mentioned in the topics earlier, which we will also dive deeper later, you will be able to see why the Employment Act 1955 is not just important for the employees, right? But it's also equally important for the employers as well. Because a lot of times out there, we always hear about Employment Act 1955, the law only protects the employees, but it doesn't protect the employers at all. Things like that. But what are the things in the law that actually protect the employers as well? This is something that we will see later further, during the training lah. Okay, and one of the most common questions that we also get from our clients is that, as long as we comply with Employment Act 1955, is it enough already? Does that mean that our company is very, very good already? Actually, no. The sad reality is that no, because Employment Act 1955 is actually, it only provides the very, very minimum requirements. Yeah. In terms of governing in the governance of the employment relationships between employees and employers. Is it sufficient? Well, I think it really depends on the type of business and also the type of company. But of course, majority of the companies, they actually strive to go beyond and above what the law actually requires them to do. But is it necessary to comply with Employment Act? Of course it is necessary, right? Because it is the law of Malaysia after all. Right? So it is very important that in order for a company to grow, to be able to grow sustainably in the future, compliance with Employment Act 1955 is very, very important. Because what is the penalty for each offence of the Employment Act 1955?
1,000 ringgit.
What?
50,000.
50,000 ringgit. Okay, so effective 1st of January 2023, any offence, all the general offences in the Employment Act 1955 can be fined up to 50,000 ringgit. Okay, so you just think about your own company and see how many 50,000 ringgit you can actually spend for each for each offence lah. Okay, so as I mentioned just now, EA 1955 is actually applicable to all private sector employees, right? But is it applicable to all private sector employees? Or just some private sector employees? All, yeah. So the answer to this is, it's all private sector employees now. So previously, before the 2022 amendment, right, it was only applicable for those that are earning 2,000 and below or only, right? But effective 1st of January 2023, the Employment Act is now applicable for all private sector employees regardless of their wages. And why is that? Where does it say in the law? So if you just flip the Employment Act 1955 to the first schedule, Okay, so usually the first the schedules of the Employment Act, it will be at the end of the act one. Okay, wait Hrdc, I think you give me first. Okay, let me just tell you guys a little bit on how to use this book. Okay, so for Employment Act or for any other acts of Malaysia, as a matter of fact, usually the front part, it will be the main act itself. Okay, and then after the main act, there will be other different orders or different regulations which are issued by the government or the minister from time to time. So that's why in this Employment Act book, you can actually see that it says that, okay, Employment Act 1955, but also including, say, Employment Information Act, Children and Young Persons Employment Act, Employment Restriction Act, and etc. There are different acts that are actually in this one book itself. Okay, and when we talk about the schedules to an act, the schedules will usually be at the end of an act, because it is similar to a contract, right? Contract, for example, the appendix or the annexure or like the schedules or whatsoever, it will usually come at the end of the document one. So in here, so in this Employment Act, so basically the first schedule is at page 105. Okay, so at page 105, you can actually see what it says, that basically who are the employees in which this act is actually applicable to. So item 1, any person who has entered into a contract of service. Okay, 1A is notwithstanding paragraph 1, the person whose wages exceeds 4,000 ringgit Malaysia, right? And for this subsection 1A, right, on the right hand side, these are basically the provisions that are not applicable for this employees who earn above 4,000 ringgit, right? So there are 6 different things that are stated there, 6 different subsections. So what are the subsections? So basically 60 subsection 3, this is on rest day pay, and then the other one is on overtime pay, and then the third one is on the entitlement of allowance during shift work. Fourth one is on for work done on a PH, public holiday, and then the fifth one is on work done on a public holiday that is a half working day, right? And then the sixth one is on termination, layoff and retirement benefits. So if you remember the question from the quiz just now, remember there was one question on what was it? Are all employees entitled to termination benefits? Okay, so I think there were 2 other scenarios as well. Was it a true or false question? False. True or false, right? So basically the answer is false. Why? Because the answer is already here, right? Termination, layoff, and retirement benefits is not applicable for those who earn 4,000, who earn above 4,000 ringgit. This is the answer to the question already. So then you might ask me, so what are the termination benefits for those who earn 4,000 ringgit then? So then that really boils down to first thing first, whether there is any contractual entitlement, meaning to say whether it's actually written in the contract or not, right? Then or the second thing will be company policy, right? Or the third thing will be mutual agreement to be discussed between the employee and the employer from time to time. Okay. So how about employees who engage in some manual work? Because if you look at item 2 of the first schedule, you will actually see that it says any person who, irrespective of the amount of wages, right, who has entered into a contract of service with an employer, right, in pursuance of which engaged in manual labor, engaged in operation or maintenance of any mechanically propelled vehicle for the transport of passengers or goods, right? Number 3, supervisors or overseas other employees who are engaged in manual labor, right? So these top 3 are the ones that we most commonly seen. Okay, the sub-item 4 and 5, not really, don't really see it very often and not really applicable for our daily, day-to-day kind of work or day-to-day business, right? But 1 to 3 are the most common ones, right? So Yes. So how about employees who engage in some manual work then? Are they also entitled, or are they subject to the 4,000 ringgit restriction? The answer is no. Right? But of course, then there is also the potential scenario where, how about if the workers are actually engaged in some kind of manual work and some kind of office job that, or like desk job, right, that doesn't actually require them to do any form of manual work, right? So the law is actually very, very clear on this. What does manual labor actually mean, right? So manual labor is only when the time during which he is required to perform manual labor, it actually exceeds 1/2 of the total time in which he is required to work in such wage period. So meaning to say that if you think about your working hours, say for example every single day, most commonly 8 hours per day, right? So if 8 hours per day, if more than 50%, which is 4 hours, you perform manual work, right, then you're considered a manual labor already. Okay, so what does this actually mean? I want you guys to think of some examples in which it is actually a combination of both manual and also desk job. Manual combination of both.
Both.
Desk and manual.
Restaurant manager.
Restaurant manager. Next one.
Okay.
Any example from the ladies here?
Supervisor for engineer.
Supervisor for engineer.
Sometimes they need to
Mm.
report, right?
Okay, yeah, I think that's true, because anyone who basically, I would say that anyone who basically supervises people who work on the ground, right, they are most of the time they are also considered as half manual, because if the manual laborer or the employee, the subordinate, it goes on leave or whatsoever, right, then they will have to go down and work on the ground to make sure that they fill in the space, right? I'm pretty sure even in manufacturing also it's the same thing as well, especially in the production line, correct? So what is the implication then? So the implication basically means that for the roles, especially like say for example retail industry or the manufacturing industry, people who are stuck in the middle management level, they are, by right, according to the law, they are actually considered as manual labor. Even if they are not considered as manual labor, they also fall under this sub-item 3, because they also supervise or oversee other people who are engaged in manual labor. So does that mean that, for example, a production line supervisor or a restaurant manager, if they earn 7,000 ringgit, if they earn 8,000 ringgit, they are not entitled to overtime? Not entitled. No. So the problem with this sub-item 2 is, look at the Employment Act. Sub-item 2, is there any provisions in which the act is not applicable? If you look at over here, it's empty, right? Right? Because the provisions in which it's not applicable is only here for item 1A, right? But for item 2, that there is no exception, right? For item 2, there is no exception. So meaning to say that actually people who are considered as manual labor or who supervise manual labor, etc., they are actually entitled to overtime. They are also entitled to rest day pay. They are entitled to public holiday pay. Because item 2, it says irrespective of the amount of wages, right? It's very clear already in the act, right? So again, I'm not telling you guys to straight away go back and change your whole company, but this is just something for us to take into consideration, right? Okay, so of course the item 1 you can see very clearly in the first schedule. It actually says any person who has entered into a contract of service right? So of course, what exactly does the law mean by contract of service? Have you guys heard of the term contract of service before? Yeah, and also contract of for service, right? Okay, so now we will go into the different types of contracts, okay? And for the first type of contract that we see is the contract of service. So what exactly is a contract of service? So over here, you can find the answer to one of the questions in the quiz as well. So, which is a contract, whether verbal or written, that binds the parties commonly referred to as the employer and the employee. Okay, so what is the full definition of contract of service? So the full definition of contract of service, including other definitions of words that are used in the Act itself, can be found in Section 2 of the Employment Act. Okay, so if you go to your Employment Act and flip to the to Section 2, right, which is right at the very beginning of the Act itself, you will see that there is a whole list of different definitions in front. Section 2. So this is a table of content. Yeah, just further down. Yeah, so this is the start. Yeah, so usually when we say section, then section 2, so then we refer to this. Okay, so section 2, this is basically on the interpretation. So these few pages, you will see is all the definitions of different words. Okay, so over here, then you will see what is the contract of service here, highlighted already. Right? So a contract of service basically it can be either verbal or written, and later we will see when it should be verbal and when it should be written. Okay, but most importantly, a contract of service, it also means that the rights of the employees are protected through the provisions contained in the employment laws. Okay, so what is a contract for service then? Usually people will also say CFS, right, or a service agreement, letter of undertaking, like, you know, there are different terms that can refer to a contract for service, but the nature of it is ultimately contract for service. So CFS basically governs the relationship between a company and a contractor, right? So the contractor is appointed to carry out a task or project, but is not subject to the company's control. This is very important, not subject to the company's control, and later we will see why. Okay, and then the third thing is the terms and conditions of the appointment of an independent contractor is actually subject to the contract mutually agreed between the parties only, right? And there is another act that governs the contract, which is called the ACTA contract, the Contracts Act. Yeah, the Contracts Act 1950. Okay, so that is the act that governs the entire relationship between a company and a contractor. Okay, so one thing that all of you need to understand is that in Malaysia, the legal system in Malaysia is basically based on the English common law system, which, because we are a Commonwealth nation, we were colonized by the British people. So our legal system is basically the same as theirs. So what does that actually mean? So what that means, and it's also very important for any managers or any business owners out there, is that the law itself doesn't just come from the Act. Okay, so the Act is what is most commonly referred to as Act of Parliament, right? Because the Parliament, they will debate, right? They will push out something called a bill, right? It's called a bill first. So they will debate on the bill. After the bill, they have already debated, it's already passed through the Parliament, and also what do they call, the House of Senate? I think that's what they call it, the House of Senate. And then it's gazetted, right? Approved by Yang di-Pertuan Agong. Then only then it becomes an Act of Parliament, and then only then it becomes enforceable in Malaysia, right? So that is the first source of law. Okay, Act, which includes things like Employment Act 1955, Industrial Relations Act 1967, and EPF Act 1991, etc. Right? The second source of law actually comes from the regulations and the orders that come under the acts. Okay, so the regulations, the orders, etc., all of these things, they actually are not debated in the parliament, right? Because these are the regulations or the rules and regulations that are decided by the jabatan themselves, by the government agencies themselves, right? And then they enforce it because it is a power that is given to them in the act, right? Because the act, for example, the Employment Act 1955, it gives certain powers to the Jabatan Tenaga Kerja, which is the Labour Department, in order to enact some rules and regulations. So that's why you will hear things about Employment Regulations 1957. What is the Employment Termination and Layoff Benefits Regulations, etc. Right? So these are the regulations and orders that are issued by the Jabatan or the government agencies themselves. So this is the second source of law. And the third source of law is basically the case laws, right? Because a lot of times the act or the regulations and orders, they are not actually very clear on very, very specific issues, right? So then that means that we need to go and refer to a case law, which is a case law is basically a law that is judge-made. So it is a case or a scenario that has been disputed in a court of law, and then the judge actually makes a decision and say that, okay, moving forward, this is the law now, okay, for this very specific issue. So that's why there is such thing as case law. Can someone give me an example of case law? Not to say the whole name, but what is an example of a common practice in Malaysia that is not governed under any of the acts, but is considered as a case law? It's not stated in the act at all, but people usually follow and it's recognized in law. Don't know. You guys will know. I feel like you guys just...
But
Yeah.
it's something related in F&B, but not, I think it's not Malaysia. Like last time we study is something that like those what you call hot cup. Hot cup. We have this but like what you call the caution hot or something like that. The label in the hot cup.
Okay.
But actually, I'm not sure whether it's indicated in the law lah.
Okay.
But what I learned last time is that there was a case before, which is actually the casualty of the patient lah.
Okay.
She actually really got hurt or burned lah.
Okay.
Because of the hot coffee. And then after that, she sued the company, and then she won the case.
Yep.
And then after that, moving forward, then you have this label in the cover. It's something
Okay.
I heard before. I'm not sure whether it's related to this one.
It could be. That could be a kind of case law because the judge in that particular case could have said that, okay, moving forward, all companies need to print this kind of label on their hot cup or whatsoever, right? That could be a case law. But how about from you guys? You guys can think of anything that is not in the Employment Act, not in the Akta Kerjaan, tapi semua syarikat pun akan ikut, pun akan buat. What's the first thing that people will undergo? The first period that people will undergo when they first join a company? What's the first 3 months of probation? Yeah, so probation is not in the act. Probation is also not in the regulations or orders. Probation is a kind of case law. But do all companies follow? Companies follow. Is it recognized in law, even though it's not stated in the act? Yes. Why? Because it is a case law that has been disputed, that has been argued in the court of law, and then throughout so many years, ever since the independence of Malaysia, it slowly became a case law, meaning to say that people or the companies will actually follow, but it is not. If you try to find it in the act, Employment Act itself, you cannot find it. Okay? Can you help? AC, panas. Because I can feel the projector.
Oh, the projector.
Wait for that.
then the resign notice period also fall under?
No, the notice period falls under the Act. Yeah.
Only like stated about how long. Apa? Maksudnya macam jawatan yang dibini kena bagi berapa. Yang tu dia tak stated.
Yeah, not stated. So again, why the three different types, right? Because it's very easy only. Because the Act of Parliament, usually the Parliament, they will not debate about, okay, like for example, what is the probationary period that you can actually give to employees, right? This is too nitty-gritty already, the details. They will just give you a very overarching principle. What is the bare minimum that the company needs to do, right? That's why Employment Act, like I said just now, is the minimum requirements that all companies must follow. And then from these minimum requirements, the orders and regulations, they come in. Because the orders and regulations usually is, I said it comes out of the acts, right? Because the acts, for example, they will say something like, the companies must provide, must give termination benefits to employees, right? Okay, so the Parliament very clear on this. Company must provide termination benefits to the employees, but how much, how to calculate, etc. So then this is where the orders and regulations they come in, because the Ministry of Human Resource or the Jabatan Tenaga Kerja, they will actually go and discuss, they will have their own meeting, they will get their own approval, and then they will publish a regulation to say that, okay, this is based on the Employment Act, this is the amount that companies must give. So that is why there is the orders and regulations. And then the third thing, which is the case law, is if the first and the second one, if there is any dispute, or I don't agree with the company, or the company doesn't agree with the employee, then what happens? Then they go to court, they sue each other, right? They go to court, and then the court will then decide what needs to happen next, right? So this is usually how the whole legal system comes about, and how it works especially in Malaysia, right? But if you go to some other jurisdictions, like for example, Thailand, or even if you go to Taiwan, for example, Taiwan's system is completely different. So that's why a lot of times the Taiwanese people, when they come here, they find it they find it quite confusing, because for them it's like very flexible, you know, very flexible to the point where you don't know what is the limit that you can be flexible on. Because for other jurisdictions, like for example Taiwan, they are very clear on. There is the constitution, and then there is the act, and then there is the regulations and orders. All of it will all trickle down to what the company needs to do. It's all very, very clear. Yeah, so this is what happens in other jurisdictions. But for our system, which is based on the English legal system, it's not like this. It can go to the left and it can go to the right. Okay? So that's why usually people will say, oh, by right it's like this, but what about by left? Okay, so there are some employers out there who prefer CFS, who prefer a contract for service, and why is that? Because they feel like there is less responsibility under the law, right? Because you don't need to abide by the Employment Act, right? I call you a contractor, and you're just a contractor, and we are just bound by the contract that we have, and also the lower operating costs because no statutory contributions. Yeah, no statutory contributions, no EPF, no SOCSO, no EIS, no HRD Corp. All of those are already add up to about 15%. Just imagine if you can cut your entire manpower's cost by 15%. It's a lot of money. Okay? And then the third one is exemption from statutory claims. Meaning to say that there are certain statutory claims in which employees can do. So for example, if you don't pay them EPF, they go and report, then you definitely kala one as an employer, right? But if you're a contractor, because it's based on a contract, so that means you have to go and fight through the normal court process and try to argue with each other and see who is the correct party, who is the wrong party here, right? But statutory claims is not like that. The law says so, you must do it. If you don't do it as a company, then you definitely salah, right? And then the fourth one is on the ease of contract termination. So of course, we already know, contract of service, there is notice period lah, we need to provide notice lah, and then when we provide notice, sometimes they can go and report us some more lah, then we need to pay even more, right? So this, all of these reasons combined together is why a lot of times companies they prefer CFS lah. But is it really true or not? Is it really applicable? What do you guys think?
Tak bagi habis lah kalau it's depend on company tu. Sebab contract for service pun dia punya keburukan dia pun ada juga. Even sebab kita nak buat satu agreement tu pun, satu agreement dengan contractor pun dia kena ikut contract act punya betul-betul. Kalau kita salah mungkin ada peluang untuk kita punya klien untuk judge kita lah. So dia ada pro and cons lah.
Okay. How about for F&B? What do companies in F&B usually use contract for services? I think it's quite rare.
Quite rare.
Quite rare.
Unless for consultant type of job lah.
For consultant type.
Like they have like 1 year, 2 years contract for you to be my consultant. But for normally like for the operation job role normally no.
I think for manufacturing, got also quite rare also operator.
Operator no, but for technician, engineer,
Yeah.
because the machine come from outside, right? So they give COF.
They give COS.
COS.
Understand.
Yeah.
Okay. So one example that I've actually encountered before, in which they actually give CFS, right, is our previous client who is a massage parlor, meaning to say that they actually provide massage to customers. They are in the retail massage industry. Okay, so when I ask them why they actually give CFS instead of COS, right, I can understand why they would want to give CFS instead of COS, because for the masseurs, a lot of the masseurs especially in Peninsular Malaysia, they actually come from Sabah or Sarawak, right? I think if you have been to massages here in Malaysia, you would know lah, especially the local ones, right? They will call it the Borneo massage or something like that, because they are all from Sabah and Sarawak. And these masseurs, they will come and go. They are like the GrabFood riders or like Foodpanda riders, right? Shop they want, shop they tak want, right? Whenever they feel like coming for work, then they will come in and work. But if they don't feel like it, then they won't come in.
Kalau tangan sentuh dua kali.
Okay. Shall we start? Can start. Okay. All right. So moving on, we will be talking about full-time and part-time employees. So I think this will actually be quite applicable for the F&B industry, because the F&B industry generally also hires a lot of part-timers, right? So my first question is, are part-time employees governed under Employment Act 1955? Yes, right? Why is that? So where you can actually find the regulations or the provisions governing part-time employees under the Employment Act, right? It's actually the Employment Part-Time Employees Regulations 2010. So it's not directly under Employment Act 1955, but it's a regulation that has been made pursuant to the Employment Act 1955. Okay, so there are two separate provisions within this regulations itself that we need to look at. Okay, so the first one is Regulation 3. So 3A, it talks about the non-application, meaning to say that who does this not apply to? Okay, so 3A, you can see that basically it says a part-time employee who is engaged occasionally or on an irregular basis and whose working hours in 1 week does not exceed 30%. Okay, so 30% of the normal hours of work. So what does this amount to then? What's 30%? What's the maximum? 45, right?
13.5.
Yeah, so maximum is 45 hours. So meaning to say that 30% is 13.5 hours. Okay, so this is the first part. So we know that whichever employee's working hours actually falls below 13.5 hours per week, they are considered as casual employee. Casual employee. Okay, and what's the second regulation then? So the second regulation is normal hours of work of part-time employee. So if you can look at this part here, okay, this is sub-regulation 2. The normal hours of work of a part-time employee shall be 70%. Okay, so meaning to say 70% of 45 is 31.5 hours. Right? Yeah. So then here we have it. So this is basically the range of working hours for a part-time employee. Meaning to say that a part-time employee, whoever that works for 13.5 to 31.5 hours per week, okay, they are legally recognized as a part-time employee. So what does it mean then if they are recognized as a part-time employee? Meaning to say that the Employment Act actually applies to them as well. Whatever provisions that we have in the Employment Act will also be applicable for them, because part-time employees are then considered as also employee under Employment Act. But the only caveat for part-time employees is that there are certain exceptions on statutory entitlements. For example, overtime work, public holidays, annual leave, sick leave, and also rest day. Okay, so this is just a very quick summary of the differences of the statutory entitlements. For full-time employee, which you will learn later, but I just summarized it here for everyone's sake, first convenience. So basically, for full-time overtime, is 1.5 times the hourly rate of pay beyond normal hours of work per day. Okay, so NWH stands for normal hours of work per day. Okay, rest day, full-time is 1 day per week. Annual leave is 8 days, 12 days, and 16 days. Okay. I think this is very straightforward. Sick leave is 14, 18, 22. Public holidays is at least 11 days. Whereas if we look at part-time, this overtime, there is a difference already on how it's calculated. Because it's 1.0 times HRP up to the normal working hours per day of a full-time employee, and 1.5 times HRP beyond normal hours of work of full-timers. So what does this mean? Meaning to say that if, let's just say, generally, I mean, tissue, I want to wipe the whiteboard. Sorry, I feel like I'm wasting your tissue. I don't have a duster. Oh yeah, that's okay. What's that?
Just now I apa ni? I guna ni. Kuat sikit. Yes.
Kesian lah ini ikan. So just now we said part-time employees is 13.5 hours to 31.5 hours per week. So normal hours of work per day. So let's just say, for example, is 9 a.m. to 6 p.m. plus including 1 hour unpaid break. Okay, so meaning to say that, what is the normal hours of work per day? 8 hours, right? 8 hours. So what this part essentially means, 1.0 times and 1.5 times, what it means is that, let's just say that, for example, you hire a part-timer, the part-timer works only 4 hours a day. Okay, 4 hours a day. And the part-timer is supposed to work from 9 a.m. to 1 p.m. only. Okay, so this is the normal hours of work for part-timer, correct? But if the part-timer actually has to do OT, right? They have to do OT until, say for example, 6 p.m. Okay, so this 1 p.m. to 6 p.m. this is still considered as part of the normal hours of work for full-timer. Correct? So let's just say that there's I put 2 p.m. here lah. Okay, 1 p.m. is the break. Okay, so meaning to say that between 2 p.m. to 6 p.m. this is still, how much do we pay? Yeah, we still pay 1.0. Okay, but only if it's 6 p.m. onwards, then it's 1.5. Okay, so this is basically the calculation is similar to a full-time employee. So for the same number of hours, it will still be considered as 1.0 times hourly rate of pay. Okay, so for rest day, for part-timer, there is a condition. They are not automatically entitled to a rest day per week. You have a question? Yeah.
If okay, usually kan F&B dia punya working hour tu bukannya static 9 sampai 6. Dia akan shift kan. Contohlah dia akan shift opening and closing. Usually lah kan. Okay, so macam mana kita nak kira OT untuk pekerja tu?
Okay, so that's why I didn't say working time. That's why the term that I use is normal hours of work. So meaning to say that it doesn't matter whether you start at 9 a.m. you start at 11 a.m. you start at 1 p.m. Your normal hours of work per day stays the same. Correct? Your normal hours of work per day is supposed to be the same every single day. Yeah. So, and one more thing is there's a condition to this full-timers. This full-timer meaning to say that the full-timer, the normal hours of work of the full-timer, it must be a full-timer in which the job and the nature of the role is the same as the part-timer. The job yang kerja tu, like for example, if you hire a waiter, you have a full-time waiter and you have a part-time waiter, okay, then I can use the 70% of whatever normal hours of work as a benchmark for the waiter, correct? So meaning to say that if the waiter works, say for example 9 a.m. to 6 p.m. full-time waiter 9 a.m. to 6 p.m. then the normal hours of work for that waiter is 8 hours, correct? So that I know that my part-timer can also work up until 8 hours at 1.0 times HRP, even though the work for the part-timer might start at 9 a.m., might start at 10 a.m., for example. It doesn't matter, okay? But if today I don't have say for example waiter that is full-time, okay, I only have a chef that is full-time. Now I hire a waiter who is a part-timer only. Then there is no similar position, right? Correct? Then that means I will just take the 45 hours divided by 6, 7.5 hours as a benchmark. Like that.
So kita boleh point siapa-siapa, tapi position lah dengan dia
Correct.
untuk kita point
Correct.
ikut follow dia punya hour dia.
Correct, correct. And why is this important? Why don't we just straight away take 45 hours? Because normal hours of work per day doesn't necessarily mean that it's 45 hours. There can be cases in which it's 40 hours per week only. Some companies do 40 hours per week, not 45 hours. So we need to see and look what is the full-timer punya normal hours of work per day. That's why we are using this.
So kalau macam contoh kita kira satu minggu, okay, macam part time kan, dia kerja satu minggu tu kalau dia lebih 45 jam baru dikira OT tu kira salah lah.
Yes, because
Sebab
the normal hours of work it's all based on per day. There's no such thing as OT after the 45 hours of work per week. Everything is per day. Later I will talk about this as well. I will point out to you why it's per day. Yeah, but to answer your question, yes, it's on a per day basis. Doesn't matter if it's only after 45 hours or not. Okay. So rest day, there is a condition to it, actually two. One is if they work 5 days or more. Second condition is if the 5 days or more add up to more than 20 hours per week, then only then they need to give a rest day. But again, generally, a part-timer doesn't need to work every single day also. So they are basically already sort of entitled to rest day. If you talk about realistically speaking from a business operations, because you are not going to ask the person to keep coming in to work for 1 or 2 hours only every single day for 7 days a week. It doesn't really make sense, right? Usually they come in, they will straight away work for at least 4 to 5 hours, at least half a working day, correct? So this is not something that I will worry too much about, even if you hire a lot of part-timers, okay? So annual leave is 6, 8, and 11. Sick leave is 10, 13, 15. Public holiday is at least 7. Now, I have a question. How do you think these numbers are derived? Do you think they just pluck it from the sky?
70% juga.
Yes. So the most straightforward way to remember, because here I think all of us can remember like 8, 12, 16, 14, 18, 22. I close both my eyes, I also can remember. But this is the part where majority of the time people cannot remember for part-timer. But the quickest way to actually calculate is actually you just take all of these entitlements here, you just multiply by 70%. Okay, so 70% of 8 is 5.6. So then you round it up to 6. 70% of 12 is 8.4, right? 8.4, then you round it down to 8. Okay, 16, 70%, 11.2. So again, you round it down 11 days. And similarly for sick leave as well. Okay, the only part that is slightly different is public holiday. Because public holiday, 11 multiplied by 70% is 7.7. If I use the logic above, it should be 8 days. But actually, in the law, it only says 7 days. So meaning they rounded down the number. Okay, so this is just more of an FYI, so that you guys can sort of very quickly try to remember what is entitlement. Yeah, so it's easy for you guys. Okay, but what does this mean then? So having said this, it also means that all part-timers are entitled to annual leave, sick leave, and public holiday. Okay, so part-time employees are not the same as casual employees. Casual employees, they are not governed under the Employment Act because they are not considered as employees, but part-time employees are employees.
So untuk public holiday tu yang 5 hari tu wajib lah kita ambil, and then
No, so for public holiday for part-timer, yang wajibnya tu adalah 4 hari.
4 hari je.
Ya, ada 1 hari dia tak ada. I can't really remember which one, but you can refer to the employment regulations. Let's see.
Can I ask a question too?
Yeah.
I want to know why part-timer also have the annual leave, and is there any minimum working hours like per week
No.
for part-timer?
Oh, so the minimum working hours for part-timer is already, like what I said just now, is 13.5 hours to 31.5 hours, correct? So meaning to say that if you work at least 13.5 hours per day, you are automatically entitled to annual leave, sick leave, and public holiday. That is your entitlement after the under the Employment Part-Time Employees Regulations 2010. And your question as to why are they entitled? So again, the reason why they're entitled is because this is a statutory minimum requirement for to protect the rights of the and welfare of the employees. Because just because it you know they don't work up to say just because they don't work up to you know a full time like 45 hours per week doesn't mean that they are not entitled to the same entitlement, right? Like they still need their annual leave, they can still fall sick, they should still have the public holidays, they should still enjoy the public holidays, right? So that's why they are still entitled, but it's at a discounted number of days. Okay. So over here, the part-time, the public holidays that are applicable for part-time employees is Merdeka, birthday of the Pertuan Agong, birthday of the ruler of the state, and Workers' Day.
The 5 compulsory.
This is a 4 compulsory for part-timer. Yeah, so the 5th one for full-timer is Malaysia Day. So that means part-timer tak ada Malaysia Day sebagai compulsory punya. Okay, next. So part-time employees eligible for other statutory benefits then? For example, EPF, SOCSO, JS, etc. Yes, because the part-time part-time employees regulations 2010, it does not explicitly or specifically remove them from the other statutory benefits as an employee. Because after all, part-time employees are employees. Okay? But of course, what is the market practice? Generally, I think generally, a lot of companies they don't provide annual leave, sick leave, public holiday or whatsoever to part-time employees. Yeah. And also because it is also understandable why. Because a lot of times, sometimes in a whole week, maybe the part-timer doesn't need to work, right? And then the following week, maybe got some work. So it fluctuates over time, correct? So when it fluctuates over time, it's also very hard to pinpoint. But if you have a part-time employee who comes to work very, very regularly, then there is a chance that that you know they are considered as part-time employees as long as they fulfill this minimum this number of working hours per week, and also that when if JTK comes and checks your schedules and whatnot, and then so usually they will, when they come for inspection, they will ask for your work schedule, they will ask for your pay slip, they will ask for your contract, etc. Right? And then what if later they see that in your schedule, how come got one person's name but not inside the one person's name in the schedule but don't have contract, don't have pay slip or anything, right? Then you will explain, this is actually a part-time employee, but then JTK might see that the part-time employee actually scheduled very regularly every single week, for example, right? So there is a chance for this kind of thing to actually to be audited or to be discovered by JTK, of course. But what is the best market practice and also the practice that is compliant with the law, we will give everything, ideally. Ideally lah. Yeah, okay. And then there might be some cases as well that on some weeks, sometimes they work only 30 hours or 25 hours, but some weeks they work up until 45 hours, for example. So in this case, are they considered as part-timer or are they considered as full-timer? Part-time. Full. For me personally, I will still consider them as part-time because there are also weeks in which their working hours drop below the 31.5 hours. Yeah. So, but my best advice would be try not to go beyond the 31.5 very, very often, because otherwise, then all of a sudden you need to give 2 more days of AL, you need to give 4 more days of MC, and you need to give 4 more days of public holiday all of a sudden. And if they try to go back several months, they try to calculate every single thing, and they want you to pay back, maybe this will be another problem again. Okay, so the best practice is always to try to control the part-time working hours. And of course, since they are considered as a part-time employee, by right, you shouldn't be scheduling them in for so many working hours. If they are really required, if the part-timers are really required to put in so many hours, you might as well just hire a full-time employee, right? Okay, so part-time employees subject to minimum wage.
Yes.
Yes, no? Yes. So yes, part-time employees are subject because they are also considered as employees in accordance with EA 1955 and therefore are included under the National Wages Consultative Council Act 2011. So this National Wages Consultative Council are basically the people or the committee members who publish the minimum wages order. Okay, so this is taken directly from the minimum wages order 2000 and yeah. Okay, so this is the latest one, yeah, 1,700 ringgit, and the hourly rate is 8.72. Okay. 8.72, we need to remember this figure very clearly.
Tapi banyak FMB RM8 kan, bagi RM8.
65 pun ada.
65.
Yeah. Yes.
Company besar tau, tidak ke bagi juga macam tu. RM8.
RM8.
Ya. Faham. Tapi JTK tak ada ni pun.
Tak ada report.
Tak kacau pun.
Tak report mah.
Yeah,
Tak report. Yeah, if no one reports, then of course, don't know lah. But if they report, then you calculate back every single thing lah. Wow. I think you kena. And usually, how have you guys kena JDK before? As in your previous jobs. In your previous jobs, have you encountered?
Normally is their parents will come and make all their parents.
Yang
Yeah.
mak, ayah.
Yeah, they will come and say, why my son work here for so long? Why no OT? Why no this, why no that?
Yeah, because if JTK comes and audits, right, usually they will ask you to back pay them. Yeah, they will ask you to back pay the employees, and then once you back pay, you need to show proof one, you need to show proof of payment and also the proof of the updated payslip. The updated payslip you also need to prove. Yeah, so yeah, so it's a bit troublesome lah. Okay, but anyway, let's come to this. How do we calculate this? How is this number derived? Okay, for example, 65.38. How is the number actually calculated?
1,700 divided 26
is
65
65/38. Okay. Then the 78.46. You tahu? You tahu? How to calculate?
Kulit dia. Oh, yang 1,700 kali dengan berapa 52 minggu tu ah.
Okay, generally, a lot of times HR practitioners out there, they will shortcut lah. For 6 days, then they will just divide by 36. And then 5 days, they will divide by, either they will divide by 22 or 21.67. Right? Just now you also got 21.66, correct? And then 4 days, sometimes they will just take this 22, they will just minus 4 days. Because one month, 4 weeks. So 1 month, 4 weeks, each week less 1 day, so they just minus 4 days, 18 days. But actually, there's a logic behind all of these calculations. And I would say, please don't use these formulas, okay? Because the best formula that we can use, and also the most correct one, is we always work backwards. Because when the National Wages Consultative Council, right, when they publish minimum wages order, they always publish the monthly rate, correct? So we use the monthly as the starting point. 1,700. We will round it up to the whole year first. Okay? Why? Because if we calculate the whole year, is it easier to calculate the number of okay, sorry, let me rephrase this. So because we are trying to find out number of working days in a week, and we want to find out how many weeks in a month, correct? What's the easiest way to find out how many number of weeks in a month? Is it easier to find out number of weeks in a month or in a year? In a year, correct? Because 1 year, how many weeks?
52.
52 weeks, right? So that means we can straight away get the weekly rate very fast already. Because 1,700 we multiply by 12 months first, right? We get the whole year, okay? And then we divide by 52 weeks, right? We divide by 52 weeks, and then we some more divide by the number of days, right? So if we divide again, then that means it's multiplied here. So we multiply by either 4, 5, or 6 days, correct? So it will be 4 or 5 or 6. So now you guys try and see if it's 4 days per week. You guys get 98.08.
Yeah.
1,700 multiplied by 12 divided by 52. Yeah. So now you get the exact figure. Okay? So now, hourly. How do we calculate the hourly rate then? If we use the same logic, we apply the same logic. Hourly.
Divide 45.
Yes. Why 45? Because it's a maximum working hours per week. So this one is you get daily rate like this, in hourly rate. So that means it's still the same thing. The other 52 weeks also the same, but instead you multiply by 45 hours. Then you will get the hourly rate of 8.72. So this is how people usually calculate. Or, well, not usually how people calculate, but this is the most correct way of calculating the hourly rate. Okay? All right. So this is what I mentioned earlier. What if the employee works just odd hours, if let's just say 10 hours per week, then they are considered as casual employees, and they do not fall under EA 1955. Okay. So just as a summary, this is what people always confuse between full-time and permanent. A lot of times people will think that permanent employment also means full-time employment, but actually these are two separate concepts. Okay, fixed term and part-time are also two separate concepts. So that's why together you get this grade. Okay, it can be a permanent full-time, permanent part-time, fixed term full-time, or fixed term part-time. Okay, these are completely separate concepts that you need to understand. All right, so I think that's pretty much on the contract part. Any questions? No, if not, then we'll go into the types of termination of contract. Okay, so there are many different types of terminations of contract. So there is termination of contract with notice, without notice, for special reasons, contract deemed broken, retrenchment, termination due to fixed term contract, retirement, or termination due to frustration of contract. Okay, so there are different types, but first let us take a look at the termination of contract with notice. Okay, so termination of contract, this is governed under the notice of termination of contract, which is Section 12 of EA 1955. Next page. And then, so Section 12 says either party to a contract of service may give the other party notice of his intention to terminate such contract of service. Okay, so the main point is at any time. Okay, the employee can submit at any time. They want to submit at 12 a.m. also can. They want to submit at 6 a.m. also can. Doesn't matter. On a weekend also can. And for the notice period, the length of the notice period under subsection 2, you will see that the length of such notice shall be the same for both employer and employee. I personally have seen contracts before in which the company only gives the employee 24-hour notice, but the employee needs to give the company 1 month notice. I think previously there are a lot of companies that do that, but nowadays it's quite rare already. But when I saw it, it was last year. Yeah, the company still does the same practice. But by right, this is wrong. And why it's wrong? Why do you think it's wrong?
Dia mesti kena sama.
Dia mesti kena sama. Why must be sama? Kenapa?
Already stated in the
If let's just say we don't look at the EA, yeah, fairness lah, right? Because otherwise it will be unequal bargaining power, right? I as an employer, I need to give you 1 month notice, but if you want to terminate me, you can terminate me 24 hours. How does that make sense, right? So that's why the EA 1955, this one is to ensure a fair employment relationship, right? And then in the absence of such provision in writing, meaning to say that in the contract itself, the employer and the employee can actually agree to any length of notice period, right? Because it says that the shall be determined by a provision made in writing for such notice in the contract of service. But in the absence, meaning to say that if the contract tak ada no such provision talking about notice period, then it's 4 weeks, 6 weeks, and 8 weeks. Okay, so this is the same thing. They will always use this length of service less than 2 years, 2 years to 5 years, and more than 5 years. Okay, 4, 6, and 8 weeks. But if, for example, my company wants to give a 2-month notice period for someone who has worked for less than 2 years, they come in straight away 2 months, kind of.
Okay.
Why?
Fair enough, 2 months.
Well, yes, but can, because it says here, length of the notice shall be determined by provision made in writing. So as long as you agree, both parties agree to it in the contract, then can already. Right? So majority, for example, in my previous industry, I was in the finance industry. Finance industry is very common, 3 months. Yeah, it's even no matter how junior you are, also 3 months. Yeah, cannot lari one. It's very, very long. 3 months is way more than this already. 8 weeks is only like not even 2 months. Yeah, but our notice period was 3 months. Yeah, so as long as it's agreed between the employer and the employee, doesn't matter. Okay.
Question.
Yes.
So let's say, because in the EA, then maximum is 8 weeks. So if the employer giving a 3-month notice period, then the employer also sign an offer letter already. But then at the end, the employee just give 8 weeks notice. In this case, what is the result?
Oh, like what can the company do? So your question is, contract says 3 months, but the employee ends up giving only 8 weeks.
Yeah.
Like, let's just say, for example, 2 months lah. So 1 month unfulfilled. Yeah, didn't serve the 1 month additional 1 month notice. So in this case, it means that actually the employee salah, because the employee already agreed to a 3-month notice, but he or she didn't fulfill the notice period as agreed between the employer and the employee. So actually in this case, there are 2 things that a company can do. Actually 3 things. First thing, can straight away deduct the 1 month salary from the earned wages of the employee. Okay, and a lot of times if it's 1 month punya salary, 1 month punya notice period that is not served, their final wages will not be enough to deduct one. Okay, so you deduct first. Okay, outstanding balance, then you issue a notice and ask them to pay back. So this is the second one, the second step. You issue them a notice. Okay, then the third one is you can go to JTK and lodge a report. JTK officer will actually call the employee and ask the employee to come and settle. But will it be settled? Very hard to say. Because sometimes the employer also cabut. They don't want to sign the letter or whatsoever, they don't want to come, you also cannot really do anything. So then some companies, they might issue, instead of a notice, they will straight away issue a lawyer letter, which is a notice of demand. Can the company do that? Can, because by right, it is really the employee's fault for not fulfilling the notice period. Yeah, but do companies do that? Generally, no, unless it's a very, very high ranking position where the salary is like 30, 40K, then all of a sudden that fella just jabut, don't come to work anymore. Then you have to quickly hire a recruitment agency to fill in the role, then you need to pay a lot of money to the recruitment agency. Then only then in those cases, then people will really go through the legal way. But otherwise, companies generally don't. Yeah, this is also on a trust basis, I would say. Yeah, but it is a protection given to companies. It's a protection given to employers. Yeah. Okay, and there is a second type of notice period. Okay, by second type I mean that there's a second situation in which this same notice period will actually apply, and whatever that is agreed in writing doesn't apply. Okay, and this is, for example, you can see under section 12, subsection 3. For example, employer has ceased or intends to cease to carry on the business, meaning to say the company to Crocodile, right? And then the place at which the employee was contracted, meaning to say if you have multiple branches, I want to close down not the entire company but just one branch only. Okay, and then the requirements of that business for the employee to carry out work have ceased or diminished. So this is, for example, redundancy, right? Your job is no longer required, okay? And then the requirements of the business to carry out work in the place, at that place again, no longer required. E, refuse to accept his transfer, okay? Unless, there's an unless here, there's a condition, unless his contract of service requires him to accept such transfer. So what this means is that if his contract of service has a transfer clause and he doesn't want to be transferred, then the employer can just terminate using the notice period in the contract. But if the contract doesn't have transfer clause and the company wants to transfer but employer rejects, then the notice period needs to be this, in accordance with the law. Okay? Then F, a change has occurred in the ownership of the business, meaning the tauke change. Okay, so these are the 6 scenarios in which a notice period must be given in accordance with the EA 1955.
Okay, change means the company still there but
change the shareholder, or change the shareholder, board of directors, all change. Yeah, but the company is still the same. Yeah. So that means there's a change of ownership, but generally ownership refers to shareholders. Okay, so can the employer refuse to accept resignation notice? Cannot, because there is no provision under the Employment Act that says that an employer can suspend, can hold, can postpone a resignation notice. And as a matter of fact, it is even said in subsection 4 that it may be given at any time, right, the notice, and the day on which the notice is given shall be included in the period of the notice. So we need to say, even if they submit at 11:59 p.m, it is still considered as they submitted one day earlier already.
Today is first day.
Yeah, correct. If I submit tonight, 11:59, today is still considered as one day already. Because it's on the day in which the notice is given shall be included. Okay? Can the employer refuse payment in lieu of notice from the employer? So just now I said, right, in following your example, notice period is 3 months. The employer wants to serve for only 2 months. First way is, like what I mentioned just now, you take the legal action. This is if the employee just straight away jump. But there are actually some employees that are very nice. They will come and talk to you, they will try to negotiate with you and see whether we can actually waive the notice period or not. Right? So if the company agrees to waive, then the waiver of the notice period, both parties can waive one. Meaning to say that the company can request the employee to go earlier, and the employee may waive the notice period and say, okay, you know what, it's okay, I don't want it anymore. Or the other way around, the employer can request the company to waive the notice period, and the company is okay with it. So the company will waive the notice period. But of course, it's more common for company to waive than the employee to waive, because the employee will always say, "Oh, you want me to go early? Then you pay me for the remaining. I don't want to come tomorrow, so never mind. You pay me for the rest of the month." So generally, employee will not waive the notice period, correct? So this is a second scenario in which the waiver of notice period can happen. So the third one is basically payment in lieu of notice. I don't want to waive. I as a company, I don't want to waive your notice period. You want to leave 1 month earlier, I don't want to waive. So what do you need to do? So you need to pay me back. You need to pay me back for the 1 month notice, for example, for the unfulfilled notice period. So you need to pay me back, and that is considered a form of payment in lieu of notice. Okay? So, but can the employer refuse payment in lieu of notice? I don't want to accept your money. I just want you to come. I want you to be here, to come and work. I don't want money from you. Sounds like very scary level. Don't need money, I just want you to be here. But can employer refuse? Can. Okay, answer is cannot. Answer is cannot, because under section 13 subsection 1, it already says that either party may terminate without waiting for the expiry of the notice by paying to the other party an indemnity of sum equal to the amount of wages which would have accrued to the employee. So put it simply, I don't need to wait for the notice period to end. I can straight away pay you how many days of wages I am supposed to earn, then I pay you that amount of money. Okay? Next, can the employer dismiss an employee without notice?
Can.
One, terminate. Actually, terminate this word terminate is a very it's a very ambiguous word, because any form of ending the contract from, I guess, from a legal perspective, majority of the time is considered as a termination. It doesn't matter. Even if they resign, if I resign, I am voluntarily terminating my contract. It's also considered a form of termination. Yeah. But here, so generally when we want to talk about firing an employee, so if we want to fire an employee, we use the term dismiss. Yeah, dismiss. So that's why in industrial court we also say unfair dismissal. We don't say unfair termination. Alright? So can the employer dismiss an employee without notice? Answer is yes, if it's due to misconduct and after investigation is conducted. Right? Because section 14, it says here, on the grounds of misconduct, inconsistent with the fulfillment of the conditions of the service after due inquiry, dismiss without notice the employee. Okay, so after an investigation is conducted, this is very, very important, because it means that you will have to do an internal inquiry first, and then again give, what is the usual process? Yeah, show cause letter, right? Then maybe you go and get witness statements, see what other people say, go and check CCTV, look back at other documents or other evidence, etc. Then only you'll come to a conclusion. Then only you take the action, right? And then sometimes in between that, then if it's a very serious misconduct, or if it's a very big company, usually they will do DI. Yeah, usually they will do domestic inquiry. Okay, so then everything, whatever that I mentioned just now, is all lumped under due inquiry. Okay, so dismiss without notice, the employer can, but subject to misconduct and due inquiry. But after receiving a resignation notice, the employer instructs the employee to stop work immediately without waiting for the notice period to end. Can the employer do this? I think this was a question in the quiz as well, right, just now. You submit your notice period, your resignation notice already. Straight away, I ask you to come already. Can or not?
You pay me,
No. Correct. Yes. Need to pay lah. Okay, I think this one very clear already. Okay, so this one I will go very quickly lah, because this one is just a very bonus topic on setting notice period. So factors in determining the notice period, for example, what is the employee's role, right? And then the type of the employment contract, whether it's temporary or permanent, and this is very important, which is the company needs. Generally, there are a lot of things that fall under company needs. For example, what is the current capacity in the company to rehire a person to come in and fill in the role, basically, right? Or how long can a company tahan or withstand without having this employee, for example, etc. Right? What are the needs, and for example, what's the training period required for a new person that comes in before the person can actually fully take on the role and be independent, right? So all of things like this are all considered as company needs as well, that a company will need to take into consideration when setting notice period, right? So it's not just about I want to set 3 months all of a sudden. All companies should set 3 months, but you need to think about, is it actually necessary to set 3 months? Because otherwise, you as the company may be the one that suffers from a very, very long notice period, and later we will see why. And of course, also, for example, employee termination benefits to be given, because if you set a very long notice period, it also means that the termination benefits might be higher because your notice period is longer. Okay. Now, I had a question just now. If I want to set a 24-hour notice period, which is what a lot of retail companies do, right? Retail industry, I'm not. I think for Mr. Wu, no lah, but I know a lot of, for example, fast-moving retail, like for example those outlets that sell clothes and whatnot. Usually they will set 24 hours. Do you think can or not?
Can.
Why?
Both agree then, yeah.
Correct. 24 hours also can. Yeah, as long as it's the same for both parties. Okay. Now, effects of an excessively long notice period. So of course, productivity will drop, motivation, they are no longer motivated, and then there could be again potential conflict and tension, right? And then team morale, there could be a negative influence on colleagues, and then financial implication will be additional costs. Because let's just say if it's an employee who is very pessimistic, she's very bad at her job, pulling the productivity of the team down. But you're not terminating the person wants to resign. You really talk to the person wants to resign, but she said she will fulfill 3 months of notice period. Then you said, GG, need to wait for 3 more months. Why did I set for such a long notice period? Alright? Yeah, so again, if you set too short 1 week, then you might be very happy that the good person, the bad person is leaving very, very soon. We only need to suffer for 1 more week. But what if the person is a good person? Correct? Then how will you be able to find another person to come in and fill in that position? Yeah, so that's why a lot of times people just put it as roughly 1 month, 1 to 2 months time, because that's usually the amount of time that can cover, posting job ads, doing interviews, coming in for maybe 1 or 2 weeks time at least to do training before the old person leaves the job. Yeah, so usually it's around this period of time. Okay. So if too short, then of course business operations will be disrupted, operations will be affected, the task transition might be a little bit harder, and then replacement recruitment and also the team workload will be high. Alright, so notice period, again, it really boils down to the type of the industry you're in, the type of company, the type of role, etc. It's really up to the company how the company wants to implement the notice period. And one more thing, notice period, if you realize just now in the act itself, they use the term 4 weeks, 6 weeks, 8 weeks, right? Why do they not use months? Yeah, susah kira.
Susah kira. Satu lagi dalam EA jelas masuk weeks tu kita dah tahu 7 hari. So bersamaan seminggu kan. So kalau 4 weeks so 28 hari senang. Kalau kita letak 1 bulan ada 30 hari, ada 31 hari, ada 8 hari. So kita tahu. Kalau contoh kalau ada cut off yang berbeza, kalau cut off 1 sampai 30 bulan, okay, senang kira. Tapi kalau cut off 25 hari bulan sampai 25 bulan tu, kita tahu berapa hari dalam bulan tu.
Correct, exactly. Yeah, because in the, again, it's the same concept just now on this. Is it easier to calculate number of weeks or number of months? The number of days in a month or in a week? One is definitely easier to calculate in a week rather than in a month, because in a month it will fluctuate every single time. So that's why generally best practice is to put it in number of weeks. So generally 1 month we will put as 4 weeks now. Okay, 2 months we will put as 9 weeks. 3 months we will put as 13 weeks. This is a general guideline for how we convert from months to weeks. And a lot of times employees are not used to this. So that's why if you want to set this kind of notice period, you also have to explain to the employee why it's 4 weeks and not 1 month exactly, for example. Yeah.